Dear students of LLM second semester, welcome you all again in my fourth video of lecture series. In last three videos, we have discussed the general principles of delegated legislation and judicial control over delegated legislation in India. In today's video, I will be discussing the parliamentary control over delegated legislation, which is given in Unit 4th of your syllabus. Friends, we all are aware about the fact that Parliament is fully authorized to confer upon anyone the power of legislation subject to the prescribed limitations, and if Parliament delegates any legislative power to any other authority, for example, executive, it must ensure that those powers are properly exercised by the administrative and there is no misuse of such powers by the executive. So we can say that parliamentary control over delegated legislation must be a living continuity as a constitutional necessity. In India, parliamentary control over delegated legislation or parliamentary control of administrative rule making is implicit as a normal constitutional function because the executive in India is responsible to the parliament. As students, Indian Parliament controls the delegated legislation in two ways, which are first, direct control, and second is the indirect control. So, if we want to discuss the parliamentary control over delegated legislation in India, then we are bound to discuss these two methods, which are direct and indirect control, in detail. So let us have a discussion on direct control of parliament over delegated legislation. In case of direct control, the important point is the laying requirement, which means that the rules have to be placed before parliament. The direct control can further be divided into two heads. The first, direct general control, and second, direct special control. The Indian Parliament exercises the direct general control over delegated legislation through first, the debate on the act which contains delegation. Second, through questions and notices. Third, through moving resolutions in the House if matter regarding delegation of power is urgent. Fourthly, through vote on grant. Friends, these are the references of direct but general control. The next and important point of discussion is the direct special control. The direct special control mechanism is exercised through the technique of laying on the table of the House rules and regulations framed by the administrative authority with the help of or while exercising the delegated legislation. But laying depends upon the requirement of laying as prescribed by the enabling act or the statute. So we can say that in India we do not have any general law regulating the laying procedure. Dear students, in the absence of any general law in India regulating laying procedure, the scrutiny committee forwarded the following suggestions. First, that all acts of parliament should uniformly require that rules be laid on the table of the House as soon as possible. The laying period must uniformly be 30 days from the date of final publication of rules. Lastly, the rule will be subject to such modification as the House may like to make. Friends, at this stage of our discussion, a question becomes relevant, that what will be the legal consequences of non-compliance of the laying provisions in India. The answer to this question is that in India, the consequences of non compliance with laying provisions depend on whether the provision in the enabling act are mandatory or directory. Friends, here we can refer some important case laws on this point. The first case we can refer is the case of Narendra Kumar versus Union of India, AIR 1960, Supreme Court 430. In this case, Section 3, Subclause 5 of the Essential Commodities Act 1955 lays that rules framed under this act must be laid before both houses of parliament, but without complying to this provision, clause 4 of the Non-Ferrous Metals Control Order 1955 was passed, and same was challenged before Supreme Court of India. The apex court held that the provisions of section 3 subclause 5 of the Essential Commodities Act 1955 are mandatory, and therefore clause 4 of the Non-Ferrous Metals Control Order 1958 has no effect unless laid before Parliament. Friends, one more case we can quote here is the case of Atlas Cycle Industries Limited versus State of Haryana, AIR 1979, Supreme Court 1149. The Supreme Court of India in this case held that the provisions of law which provided that every order by the central government or its officers or authority shall be laid before both houses of parliament as soon as may be after it is made are merely directory in character and did not make laying a condition precedent to the making of the order. This is all about the direct parliamentary control over delegated legislation. And the next control is the indirect control. Friends, in India, indirect control by parliament is exercised through its committees known as first Committee on Subordinate Legislation of Lok Sabha, which was set up in 1953, and this committee consists of 15 members appointed by a Speaker of Lok Sabha for the period of 1 year. The second committee is Committee on Subordinate Legislation of Rajya Sabha, and this committee was constituted in 1964, and this committee again consists of 15 members nominated by the chairman of Rajya Sabha and continue in the office till new committee is formed. Friends, these two committees were given the main task to scrutinize and report to the concerned house that whether the power to make regulations, bylaws and rules are conferred by the constitution or delegated by the parliament are being properly exercised or not. With this main task, the committees are having some other functions too, which may be discussed with reference to both the committees separately. as far as the main functions of the committee of Lok Sabha, Lok Sabha is concerned, it is prescribed under Rule 223 of the Lok Sabha Rules of Procedure, and according to this, the main function of this committee is to examine the following aspects. First, whether the rules are in accordance with the general object of the act or not. Second, whether it directly or indirectly bars the jurisdiction of the court. Third, whether it is retrospective in character or not. Fourth, whether there has been unjustified delay in its publication or laying. Fifth and last, whether for any reason rules and regulations are required further explanation or not. The main function of the Committee on Subordinate Legislation of Rajya Sabha is somehow similar to the Committee of Lok Sabha, but to streamline the process of delegated legislation in India, this committee has made following recommendations. First, power of judicial review should not be taken away or curtailed by any rules. Second, language of the rules should be simple and clear. Third, rules should not be given retrospective effect generally because they may prejudicially affect the vested rights of a person. Fourth, legislative policy must be formulated by legislature and power to supply details may be left to the executive. Fifth, discriminatory rules should not be framed by the administration. Sixth, rules framed should not go beyond the rule making powers given by the parent act. Seventh point we can incorporate is the final authority of interpretation of rules should not be with the administration. The next recommendation was that the sufficient publication should be given to the statutory rules and regulations. Friends, on the basis of the above mentioned discussion about parliamentary control over delegated legislation, we can conclude that in India, if we want to have effective and living parliamentary control over delegated legislation, then it is necessary that the role of these two parliamentary committees on subordinate legislation must be strengthened and a separate law providing for uniform rules of laying and publication be passed, and if possible these committees may be supplemented by a specialized official body to make the administrative rule making or the delegated legislation more effective. Thank you very much.